This is Corey Talbot at Holland & Hart. It's nice to have you on line today for the first of our 2021 Holland & Hart Healthcare Compliance webinar series. Traditionally, early in the year, we have an in-person boot camp where we go over a lot of the issues that we'll be discussing throughout the year in a single 2 or 3 day meeting, and we wish we could do that and see everybody in person, but these are the times we live in, and so we'll just have to muddle along online as best we can. As I said, my name is Corey Talbot. I'm a partner in the Salt Lake office of Holland & Hart. My practice is generally litigation, but I do get involved in telehealth matters in healthcare and antitrust matters in healthcare, and I'll be speaking about both of those throughout the year. And we're going to start things off by talking about telehealth in 2021, and sort of where we are, where we've been, and where we might expect to be. If you have any issues throughout the presentation, connectivity, those sorts of things, feel free to put that in the chat, and we'll see what we can do. If you have questions, also put those in the chat. We probably won't have time to get to questions today, but please enter them. I can respond later on by email or phone. We can go over any particular questions we have, but generally we have not been able to do that as part of these presentations. So that's one disadvantage of not being in person. It makes it a little trickier, but like I said, we'll muddle through as best we can. So why don't we go ahead and get started? Let's talk about telehealth. This is what we're going to be going over today. We're going to be talking about data security and privacy issues, licensing, credentialing, reimbursement, informed consent, prescribing controlled substances. And generally, in these topics, we're going to be talking about where we are and what is going to happen next. This will necessarily, of course, require some context, and so we'll be going over a bit of background information on some of these different points. And the context of all this, of course, is the public health emergency that the Secretary of the Department of Health and Human Services declared last January in light of the COVID-19 pandemic. This public health emergency lasted for 90 days, but that 90-day period can and has been extended frequently over the course of the last year, and the public health emergency remains in place. And what that's done, kind of big picture, is it has given HHS and related agencies some additional authority to provide for services that otherwise wouldn't be allowed under the existing regulatory and statutory schemes. Now, this has been a real boon for telehealth because it has substantially increased over the last year. And that has been, by and large, very advantageous. And the issues that we're coming to deal with here over the next several months will be, how does this play out once this public health emergency comes to an end, which we all hope is sooner rather than later. The issue is that because these agencies have additional authority during public health emergencies, they have expanded services, and telehealth is a good example of a type of service that has been significantly expanded under this emergency authority. But when that emergency ends, so does the authority to expand those services. And so some of the changes that have been made are appropriate permanent changes. Others are temporary changes. And that has been a boon as far as providing services. It does complicate matters as far as compliance goes, though, as hopefully over the next several months, some of those temporary changes will be going off into the sunset. So we'll try to get into that, but like I said, there has been a lot of change in telehealth especially, and so we're probably not going to be able to get into the weeds on each of these changes and how long they're going to be effective, but we'll try to get into that as best we can. Okay, let's start off by talking about data security and privacy. Of course, the framework for this is generally under HIPAA. You also have state law requirements, generally very similar to HIPAA. And HIPAA requires that you implement, covered healthcare providers implement physical, technical, administrative safeguards to protect electronic personal health information, and that includes transmission security, it includes integrity controls, and it includes encryption. You have to have those safeguards in place to protect personal health information. And so, the HIPAA requirements largely grow out of those basic requirements. And so covered healthcare providers have an obligation to provide secure communication to protect electronic protected health information, and they have to put it on a system that allows them to monitor communications containing electronic protected health information so that they can be sure that they are able to prevent security breaches, establish when that's occurred, and lock it down as quickly as possible in the event there is a security breach. And so those are sort of the technical requirements that covered healthcare providers have to protect electronic personal health information. Beyond that, there's also a requirement for physical security. This is, I think, fairly common sense that even if your communication channel is HIPAA compliant, you have to act in a way that is physically going to protect that information. So, for instance, a doctor shouldn't be speaking on speakerphone in the lobby of her office with a patient about personal health information that would otherwise be protected under HIPAA. And so HHS recommends that you try to have privacy, and where that's not possible, they have provided recommendations using lowered voices, not using speakerphone, recommending the patient move to a reasonable distance from others when discussing PHI. This is one where, notwithstanding the technical system in place, it's important that providers use common sense in maintaining that confidential information. Another aspect of HIPAA, of course, is business associate agreements, and those are provided largely with vendors or other outsiders who assist with the provision of telemedicine. It doesn't include other treatment providers. Those are not treated as business associates. These are entities that transmit and have regular access to PHI, not a conduit, but who actually do the transmission with access to personal health information. Similarly, an entity that stores PHI, you'd want to have a business associate agreement with them. Some exceptions: members of your own workforce, if you're a covered health provider, if you have control over the person on site while they're doing their work, you don't have to have a business associate agreement with that person. You're members of an organized healthcare arrangement where you are providing an integrated service of delivering healthcare. That's also an exception to the business associate agreement requirement. And so this is sort of the framework that we're used to, that was in place before this pandemic started. Now, when we got into the pandemic, it became apparent very quickly that telehealth would be not only beneficial, but in many cases necessary for people to get adequate health care. And so the HHS Office of Civil Rights, OCR, issued what it called a notification of enforcement discretion. And that notice empowers covered healthcare providers to use popular apps without risking to communicate with patients without risking penalties for violating HIPAA rules when they are engaged in the, quote, good faith provision of telehealth services. So what does that mean? Well, it means that you can use non-public facing applications. And there are some examples here. These are actually taken from the HHS website. These are the examples that they give on there of applications that seem to fit the bill. Now, I want to be clear that the agency is very sure to put a disclaimer on its site that it's not vouching for, say, Apple FaceTime as a compliant means of providing telehealth services. But these are some examples of non-public facing applications that are the type of applications that the agency is okay with using for telehealth services. So you got FaceTime, Facebook Messenger. Those are video chat applications. One other change has been the use of text-based applications, and that sort of came along a little later, where HHS approved the use of text-based applications, and they give some examples here of text-based applications, non-public facing again, that are appropriate to use for providing telehealth services. And the distinction, of course, is the public-facing issue. These applications that HHS is has told us we can use are non-public facing. They're not public facing like Facebook Live or Twitch, where members of the public can view information that's being shared. Those are out. So what does this mean? OCR has said it will exercise enforcement discretion regarding providers who deliver services without meeting all HIPAA requirements. Will not penalize providers for good faith use of telehealth services. And and some more good news on this. HHS expanded immunity here back in the beginning of December related to the provision of telehealth services. All good things. I think I'm optimistic that this is a concern largely for attorneys who look at things like this and think, well, gosh, is there a way you could be liable? Yeah, I guess there is. But I'm really hopeful and optimistic so far, based on what OCR has done, that they really do mean this. That as providers are acting in good faith to use these apps for their telehealth services, they are not going to be met with enforcement if things do go wrong, but that there is an understanding that this is a process that was put in place very quickly to deal with a pandemic, and there are going to be ups and downs along the way, and that's been the case so far. One thing to think about, though, is what do you do with known security risks? You may remember at the outset of the pandemic, when everybody downloaded the Zoom app for the first time in their lives, that there were rumors going around that there was a security glitch and people could get your information on a Zoom call, and with those sorts of things going around, would that still meet this standard of providing the telehealth services in good faith using the Zoom app? As it turns out, that may have been the security risks with Zoom may have been overblown, so that ended up not being an example that we ever got any intelligence on. But it's something to think about as you are choosing applications to use in providing telehealth services. And this is really because, frankly, there have been, in addition to, some accidents, mistakes that happen along the way, we've had an increase in bad actors who are trying to access sensitive information that is now more vulnerable as a result of being used in ways that, at least, a year ago, were not contemplated by by many healthcare agencies. All right, so what do you do then? If you want additional security, use technology of vendors that are HIPAA compliant and will enter into HIPAA business associate agreements with you. Again, HHS has identified a number of companies on their website, they're listed here, that at least have told HHS that they provide HIPAA-compliant video communication products and will enter into HIPAA business associate agreements. Now, again, OCR hasn't vetted that to make sure that's the case, but this is out there as a resource to use that at least these companies believe that they have met these HIPAA standards. Other technology vendors, though, as well, may also provide HIPAA-compliant video communication products and be willing to enter into those business associate agreements. So don't see this list as sort of the be-all, end-all of products. All right, so that's sort of where we are now, and let's talk a bit about what's next. There have been a lot of calls to return to pre-pandemic requirements to protect patient privacy, and this is where we have some priorities that frequently are competing. We have a priority of expanded access to telehealth services. We've seen that it's been very beneficial throughout the country, but we also have priorities of protecting, patient health information, protected health information, and cybersecurity. And those priorities sometimes bump up against each other. And so as we look at what standards healthcare providers are going to be held to, we don't have anything directly on point right now. But what we do have is some information coming in from other sources that will apply, or at least could apply, to telehealth services. I've noted one here. The Office of the National Coordinator of Health Information Technology published final rules this last year about adding safeguards for electronic protected health information. It wasn't tied directly to telehealth services, but it's likely going to impact it. Similarly, at the end of 2018, beginning of 2019, HHS released a publication about cybersecurity practices and came up with a framework to comply with the Congressional Cybersecurity Act of 2015 mandate to develop practical cybersecurity guidelines, best practices, procedures, and processes to cost-effectively reduce cybersecurity risks in the healthcare industry. Now, that is something that may, at times, those guidelines, because they constitute best practices, may become the standard of care that is applicable to data security and privacy. And as those go up, it may be more difficult to expand the services at the rate that HHS at least would like to see. For sure, though, well, perhaps not sure, but I think much more certainly what we are going to see is enhanced training about patient privacy. I think we're going to see requirements that appropriate business associate agreements are in place. I think we're going to see a lot more regulatory guidance and enforcement regarding cybersecurity going forward, especially as the pandemic sort of fades into the rearview mirror. And we're going to see a push for greater access to adequate broadband connectivity. We've already seen that. Congress has been working to address this issue, and states are as well. So this is something that is important if we're going to continue to have this expanded range of telehealth services across the country. All right, so that's a quick overview of data security and privacy. Let's go on then and talk a bit about licensing. Licensing is a little tricky to address, mostly because it is a state-by-state issue. Practitioner, you've got to be licensed in the state where the patient is located typically and comply with that state's licensing and scope of practice laws. It applies to a wide range of practitioners, as I've noted here, and because it's a state-by-state issue, it can be a bit time-consuming. As a result, there have been a variety of processes, but they're all sort of nothing's really gelled across the country. What you do have are sort of patches that different states and different regions have come up with to deal with issues about licensing. You do have interstate licensure compacts, and I've identified some of them here, that will help to ease the burden of licensing across jurisdictions. You have licensure by endorsement or reciprocity. For instance, Virginia has that reciprocity rule You have contiguous state rules, and Ohio has that as an example, that if you are residing on the border of a contiguous state with Iowa, that's sufficient for licensing purposes. And then telehealth registration programs that specifically apply to telehealth. And I think Florida has a neat telehealth registration rule that allows out-of-state practitioners to provide telehealth services to patients within Florida. So there are some mechanisms that have been used to streamline the licensing process. Again, the downside is it's really sort of a patchwork system, and it depends on where you are. And so no matter what you're doing, you still have to check in every state where you are seeking to have practitioners licensed. And, sort of going along with this, beyond licensing, you're going to have limitations on scope of practice. You're going to have different state supervision requirements, different prescribing limitations, and so on. And so, again, you're going to have to check on a state-by-state basis. And some states do have telemedicine-specific rules. Some don't. Some do. For instance, Maryland is a state that does have a variety of requirements and safeguards related specifically to telemedicine. So what's happened to this process during the pandemic? Well, the good news is you've got relaxed licensure requirements. And so, again, you've got Florida is another example of this. We talked about their registration rule earlier. Even beyond that, eligible healthcare professionals in Florida who are licensed in another state can provide telehealth services to Florida patients, even if they aren't licensed or registered in Florida. So that's been, an example of that relaxed licensure requirement. Again, though, the downside is it's a state-by-state issue. The Federation of State Medical Boards has actually done, I think, a really good job of providing information about which state requirements for telehealth have changed in response to this COVID-19 public health emergency. I put the link on here, and this it's a PDF that they have that goes through each state by state and talks about the changes that the states have made in response to the pandemic. It is actually updated, and I think the last update I saw on this was it was either late December or even maybe early January of 2021. I think this was actually late December, but it's a really good source as a starting point to look at licensure requirements and how that may have changed in response to this COVID-19 pandemic. So what's next? We may see some permanent changes out of this. We may see, for instance, more states like Florida coming up with rules that will allow people to provide telemedicine services, allow practitioners to provide telemedicine services across state lines without having a full-blown license in the jurisdiction where the patient is located. I think that's probably likely that we'll have some changes like that remain permanent. Emergency orders, though, that relax licensure requirements are going to be lifted, and I think we're going to see an increase in licensure portability, but at the same time, it's not going to be uniform, and so it's still going to require a bit of legwork to understand different jurisdictions' requirements. All right, so that's licensing. Let's move on and talk a bit about credentialing. It's kind of a related topic. Licensing is your authorization to practice medicine. That's a state-by-state process. Credentialing is a verification of education for practitioners, insurance, licensing to ensure that practitioners meet the standards of practice. And this is a process for a healthcare facility, a hospital, to engage in, and each site has to deliver. Each site that's delivering telehealth services has to credential the provider. Purpose of credentialing, again, is designed to protect patients. It's ensuring that telehealth providers meet standards that are set out in each state's licensing requirements, as well as policies for the actual healthcare facility that may be different or in addition to state requirements. one problem with this, and it's a significant one, especially for rural facilities, is the time and money it takes to engage in the credentialing applications. These are some averages that I found about the process. That facilities spend over $7,000 a year on credentialing applications for one state. Administrators spend about 20 hours to credential every provider, and it can be 2 to 3 months before you get through that credentialing process. Those are some averages, but you can see, and maybe you have already known, that this is it's a time-consuming, expensive process that tends to slow things down. So what do you do? A lot of rural hospitals, what they've done is they contract with distant providers for healthcare services, and if you're a patient, you've just got to travel to receive that care, or you're going to go without that care because the rural hospitals simply don't have the resources to engage in credentialing. And so that's led to this solution of credentialing by proxy, which allows a hospital to receive telehealth services by accepting credentialing decisions of the distant site hospital where the provider is located. You've got to be a little careful if that seems like a solution to you. Make sure your bylaws permit credentialing by proxy. And you also need to be sure that in engaging in this credentialing by proxy, you do it in a way that you comply with Medicare conditions of participation, because otherwise you're not going to get reimbursement from Medicare and Medicaid programs, and that is not something that we want to see. So conditions of participation, here are some requirements that we need to have in place if you're going to engage in credentialing by proxy. Written agreement, distant site participates. You've got some requirements that the provider is going to be evaluated. That evaluation is provided to the distant site, inform of the distant site of any complaints or concerns regarding the services. And the requirements are going to differ slightly from facility to facility. So your critical access hospital is going to have slightly different requirements. And so it's important that you dig in and make sure that you are following the right list of requirements if you're going to engage in credentialing by proxy. All right, so what's happened during the pandemic? Again, the Federation of State Medical Boards done a really good job of trying to expedite credentialing. Congress passed the CARES Act, and it's tinkered with this a bit to provide additional funding for telehealth and other related issues. It's available to nonprofit, public eligible healthcare providers, and has provided several $1 million in requests for credentialing assistance. And so that's been a good resource during the pandemic. Where are we going to go from here? That's kind of the next step. And what you see is, not surprisingly, industry calls to streamline the credentialing process. What we don't know is how states are going to react to that in light of this pandemic that we've gone through. In favor of streamlining that process, I think states have seen that there really is a benefit to having healthcare providers able to respond quickly, where otherwise you would not have adequate healthcare providers. There are some technology, some programs that are offered by private entities that can streamline the process as well that benefit providers. There have been proposals to expand the scope and funding of the CARES Act program, including using that for credentialing, so that's been good. But again, much of this comes down to what are states going to do. If states are going to streamline the process, you've got to have sort of a critical mass of states that are going to work together to do that, and until that happens, this will always be a process where you just have to go through on a state-by-state basis for credentialing. All right, so that's credentialing. Let's move on and talk now about reimbursement. We're going to focus mainly on Medicare reimbursement because that's the a national one that doesn't change every time you go to a different state or a commercial if you have a different payer. So we're going to focus mainly on that, but we'll talk a bit about Medicaid and commercial payers. So let's talk about reimbursement under Medicare. Medicare, of course, let's step back into our early 2020 shoes. Medicare provided pretty limited reimbursement for pretty limited telehealth services. That was limited in part by the originating site. The patient's location had to be in a rural health professional shortage area in a county outside of a metropolitan statistical area, and that originating site had to be in a facility authorized by Medicare. And so you'd have to go, if you were a patient engaging in a telehealth visit, you'd still have to go somewhere. You'd have to go to a hospital or another doctor's office, but generally you couldn't just be at home as the originating site for those telehealth services. There was a limited number of providers that could offer telehealth services, and the technology, there was a requirement. It had to be interactive audio and video telecommunications permitting real-time communication. That was a part of providing telehealth services. So what happened then when the pandemic hit? Well, a lot. CMS has taken a lot of steps to expand telehealth coverage during this public health emergency. And, frankly, just last month, the Secretary, Alex Azar, said these actions have unleashed an explosion in telehealth innovation. We're now moving to make many of these changes permanent. And we're going to be talking about some of those changes that they have worked to make permanent. This is where we see HHS sort of bumping up against the edge of its authority. CMS is limited in its ability to expand Medicare telehealth coverage because it's an agency. It has to act within the statutory framework that it operates under. Now, public health emergency, it does provide more leeway for them to enact regulations and provide sort of emergency changes to those regulations, but it's temporary. And let me give you just a quick example. CMS had previously created a temporary coverage policy for evaluation and management services provided via audio-only connections that would end upon the expiration of the public health emergency. Because of statutory limitations, CMS could not propose to continue payment for those services beyond the public health emergency. It cannot waive the requirement that telehealth services be furnished through an interactive two-way audio-video connection. Okay? And so CMS recognizes the utility of that service beyond the public health emergency, and it may be prudent in mitigating infection risks. So the final rule that CMS implemented last month on an interim basis, you have a new code representing 11 to 20 minutes of medical discussion in determining whether an in-person visit is required. So that's an example of something where CMS wanted to make a permanent change but was unable to do so because it has to fit within the statutory framework requiring that audio-visual connection rather than an audio-only connection. That said, and as a result, a lot of the permanent changes that people are hoping for or are advocating for are just going to have to wait for some type of congressional action if they're going to move ahead. All right, so what are some of the changes that have been made? The first that we're going to talk about is the expansion of the permissible originating sites. And so as a result of this, patients no longer have to leave their residence and go to a doctor's office. They can have their residence as an originating site. The telehealth services can be provided outside designated rural areas. And so that change alone has been a huge boon for telehealth services. You also have an expansion of services, and I've got some more information on that a little later, but an expansion of services that are eligible for Medicare reimbursement. You've got reimbursement at in-person rates for telehealth services. You've got reduced or waived cost sharing requirements, and Medicare will allow payments for practicing across state lines. Now, this is subject to requirements of the states involved, so don't view this as carte blanche just to start providing telehealth services across state lines. You still have to meet state registration or licensing requirements as well. Another change, physicians can see new and established patients for telehealth and other visits using communications technologies. We've got, and this is a change that for nursing facilities that is already subject to a temporary waiver, but just went into the final rule in December for Medicare. The final rule for Medicare payments for 2021. In response to industry concerns about the 30-day frequency limitation on subsequent telehealth nursing facility visits, that frequency limitation has been dropped down to 14 days. And again, the balance well, not again, but the balance that HHS is trying to strike here is that they want to promote telehealth in nursing facilities while also ensuring that providers are not disincentivized to provide in-person care. You've got scope of practitioners that has expanded as well. As outlined in the final rule for 2021, licensed clinical social workers, clinical psychologists, physical therapists, occupational therapists, speech-language pathologists will all be able to bill for brief online assessment and management services, virtual check-ins, remote evaluations. That's been expanded under the final rule for 2021. Direct supervision. Physicians can supervise services through interactive audio-video communication. So the current definition of, and that change really comes in, the then current, 2019-2020 definition of direct supervision required a physician to be physically present in the office and immediately available to furnish assistance, direction throughout the performance of a procedure. Under this new definition, though, now direct supervision can be met if the supervising physician is immediately available to engage via interactive audio-video. The change doesn't require real-time presence or observation of the service via interactive audio-video technology throughout the performance of the procedure, but audio-only technology is not going to be sufficient to fill the direct supervision requirements, and so that opens opportunities for telehealth and incident-to billing. This is a temporary one, though, that will expire at the end of 2021. You also have changes to supervision of residents for residency training sites and teaching settings outside of the metropolitan statistical area. Teaching-only physicians can use interactive real-time audio-visual, not audio-only, to interact with residents through virtual means to meet the requirement that they're present for a key portion of the services. And this is a real benefit, and it's an effort to increase benefits to Medicare-covered services in rural areas, expand training opportunities in rural areas, and so they've made that flexibility permanent outside of metropolitan statistical areas. Now, you do have to have medical record has to show how the teaching physician was present to the resident during key portions of the services. Flexibility, this does not apply to surgical, high-risk, interventional, or other complex procedures. It doesn't apply to services performed through an endoscope or to anesthesia services. It also applies within the MSA for now, within the metropolitan statistical area, but that flexibility is going to expire at the end of the public health emergency, and so it'll go back to in-person requirement for that. So the modality for telehealth services, like I said at the outset, it required communications equipment that includes at a minimum audio and visual equipment, allowing two-way, real-time, interactive communication. And now one of the changes we've seen that in some circumstances you can have audio-only as a method of communication to provide telehealth services. Expanded services, I mentioned this earlier, and I had this link that I wanted to pass on to you. This provides the most recent codes that were approved by CMS as part of its Medicare Physician Fee Schedule final rule for the calendar year 2021. Made pretty significant changes. As part of the final rule, CMS included a number of changes reflecting permanent shifts to the healthcare system by expanding reimbursable telehealth services, including beyond the public health emergency. And so what we see is there are a couple types of changes generally that are made. Several codes that were added earlier during the public health emergency will remain on the approved telehealth list permanently. And then you have some where CMS has now created a new category of telehealth codes that are added on a temporary basis to the approved list of Part B telehealth codes. And those were added on a Category 3 basis, so they're going to be covered for the duration of the public health emergency and during the year in which that public health emergency ends, but not beyond that, absent additional work. So that's sort of where things stand right now. Another change, federally qualified health centers, rural health clinics can provide telehealth services to patients wherever they're located, including in their home. It includes audio-only telephone evaluation and management services, some of the changes. So what's next? Administrator Verma said that she can't imagine going back. We are going to have quite a bit of changes in telehealth that are going to be permanent, I think. There are about a dozen bills in front of Congress right now that address telehealth in some way, shape, or form. I'll give you an example of this. The Permanency for Audio-Only Telehealth Act, which is in front of Congress right now, it removes technological geographic restrictions that would inhibit telemedicine services in rural areas. And this is the result of lacking adequate broadband connectivity to support audio-visual telemedicine technology. And so it would reimburse providers for evaluation and management services, mental and behavioral health services, even if they're only using that audio telehealth platform. And it would also allow HHS to add medical services for audio-only telehealth coverage and allow Medicare beneficiaries to receive that from their home. Again, we're not going back to the pre-pandemic originating site requirement that you go to another doctor's office or a hospital. This act would eliminate that requirement in these circumstances. So that's a bit of a taste of what may be coming up for Medicare, and we'll have to see what the new Congress does with this and what the new administration does with this. But I think it's safe to say that we're going to see some pretty significant movement at a congressional level to expand telemedicine services. All right, so let's talk a bit about Medicaid. And again, I'm not going to be going into as much detail on this because it's going to vary from state to state. You've got different conditions from state to state, different requirements. For instance, some states will allow audio-only telemedicine services. Some require synchronous audio and video. You're going to have different documentation requirements. You're going to also have different parity requirements where you're going to have parity with respect to the types of services that are being provided and the rates for those services. So you're going to have those differences from state to state. What we've seen during the pandemic is generally an expansion of practitioners that can be reimbursed under Medicaid, an expansion of the types of services that are reimbursable, an expansion in the modes of communication, and an expansion in the ability to establish a physician-patient relationship. And it's, right now a lot of these are temporary changes, so we'll see what happens. But here are a couple examples. Michigan, like other states, expanded telemedicine, authorized for Medicaid, allowing audio only. In the commercial setting, we've seen similar similar rules where requiring private insurers to invest for telehealth services. That's that parity requirement. What's going to happen next for Medicaid and commercial payers? Well, it's kind of hard to say, and that's going to vary a lot from state to state, and I anticipate that you're going to see a lot of differences between the ways that the state responds. I think this has been a real good thing for a lot of states with heavy rural populations, and they're going to be under a lot of pressure to keep those benefits in place for those constituents. All right, so let's talk a bit about informed consent now. The standard generally for informed consent is that the patient understands the nature of the care being provided, the anticipated benefits, risks, and alternative. Does that consent have to be spoken or written? That can depend on the circumstances, but this is a state-to-state issue, and in some cases, it can depend on the location within the state whether there's informed consent. And so really kind of best practices, any form should be specific to telehealth or specifically contemplate telehealth. Consider the security issues, technical issues, decision-making issues, the appropriateness of telehealth for the service being provided, and other intake forms that have already been executed by the patient, notice of privacy practices, financial responsibility, and so forth. Make sure that your consent forms account for those considerations. Let's talk, and again, informed consent. As far as going forward, we'll see. I don't foresee any decrease in the requirements for informed consent as a result of the pandemic that are going to have any lasting impact. So let's talk about move on to prescribing. Telehealth providers generally subject to prescribing rules that are set under licensure regulations. So this is frequently a state-by-state issue where you have additional federal limitations and frequently state limitations for telehealth. Dealing with controlled substances, it's going to depend on the patient location, it's going to depend on the physician-patient relationship, whether it's an emergency, and whether we're talking about the medication-assisted treatment of an opioid use disorder rather. All right, so telehealth services and prescriptions, the big statute that prevented prescribers from issuing a valid prescription for a controlled substance via internet was the Ryan-Haight Online Pharmacy Consumer Protection Act of 2008. This act was passed in response to some of these online pharmacies that were prescribing medication without having in-person medical evaluations before doing so. And the act prohibited that, but one exception to that was a public health emergency. And so when HHS declared a public health emergency, it triggered that exception to the in-person medical evaluation requirement in the Haight Act, and that allowed for online prescribing. What we've seen now is DEA will allow registered practitioners to issue prescriptions to patients with no in-person medical evaluation under certain circumstances. So you have to have, it's got to be for a legitimate medical purpose, by the practitioner in the usual course of his or her professional practice. That's key. It can't just be, it has to be within the course of the practice. Telemedicine communications conducted audio-visual, real-time, two-way interactive communication system, and it has to comply with applicable federal and state laws. So this is not a workaround state law requirements. It has to meet state law. And the other thing that DEA is now allowing is qualifying practitioners can prescribe easy for me to say, buprenorphine, which I am saying wrong, I know, to new and existing patients with opioid use disorder based on telephonic evaluation. All right, for more specific requirements, I've got a link to a few information pages from the DEA on that, those changes during the pandemic. So in conjunction with this, many states have followed this course and said they would not impose penalties for noncompliance with state regulatory requirements for in-person medical examination before a prescription is made. But not all of them have, and some have in different degrees. And so please don't just rely on the DEA guidance. You're going to have to figure out on a state-to-state basis what requirements exist. So what's going to happen here after the pandemic? There's been some discussion about changing the way that prescriptions are made to address the opioid epidemic, but it hasn't really been tied to the public health emergency. It's sort of just been the experience with the opioid epidemic generally that's informed those discussions. And so I think given the risks of loosening those restrictions, you're going to see in-person prescribing requirements return shortly, with the end of this public health emergency. That's I think the most likely outcome. All right, so we've gone over these topics and hit on data security and privacy, licensing, credentialing, reimbursement, and informed consent, prescriptions. Just some takeaway points that I want to offer to you as we wrap things up here. We're dealing with federal and state requirements. Largely we focused on the federal ones, but please check your state requirements for telemedicine services. Especially if your services cross state lines, you've got to check both states to make sure that that you're in compliance at the originating and distant site states. Licensure, make sure you know what your state has changed regarding licensure so that you're not caught off guard. Make sure you know what you need for informed consent, especially if you're providing telehealth services across state lines. Again, informed consent varies from state to state, and so you need to make sure that you're complying with both states' laws. Standard of care for telehealth, again, as you cross state lines, you're going to want to know what the standard of care is in each of those jurisdictions. There's generally not a different standard, though, for telehealth versus in-person care. Really what we're talking about here is the difference between standard of care in each state. And insurance is another issue that you're going to want to make sure that you've got in place. If your insurance doesn't allow you to practice across state lines, you're going to have to take care of that before you start offering those types of services. So just a couple of high-level comments here as we wrap up. For some more resources, Department of Health and Human Services has a pretty good overview of telehealth issues at its website, telehealth.hhs.gov. I recommend that you take a look at it. Center for Connected Health Policy does as well. And so those are some resources that you can look at to provide you with additional resources. Other than that, if you have any questions, feel free to shoot me an email. Give me a call. I'm happy to chat with you. And so we'll go ahead and wrap that up here. Everybody have a wonderful afternoon. I appreciate you joining us and look forward to seeing you at the next webinar.